Next up, we have Jonathan Gu from the New South Wales Bureau of Crime Statistics and Research.
Hi everyone. Today I'm going to be talking about some work I've been doing looking into whether a High Court decision on doli incapax shifted court outcomes for 10 to 13-year-olds. I'm going to start today's presentation first by talking about some of the background that has given rise to this study, before then going into what doli incapax is, the data sets that I've used, and then the bulk of my presentation will be focused on the trend analysis and the results that I found. This piece of work really begins at a point where, as you heard from the previous panel discussion, that there's been a huge debate across Australia about the minimum age of criminal responsibility. We have different directions taking place where the ACT and Victoria have raised the age, whereas the Northern Territory has gone in the opposite direction of lowering the age. There's also a significant chunk of jurisdictions in the midpoint. But the point I want to raise here is that while the debate on minimum age of criminal responsibility has been raging, there has been another issue which has received considerably less attention despite having a fairly significant role to play when it comes to acting as a gateway for whether 10 to 13-year-olds enter the criminal justice system. And that's the principle of doli incapax, which in New South Wales it's instructive to think about a couple of different age groups. Firstly, children aged under 10 cannot be found guilty of a criminal offence. But children aged 10 to 13 are presumed to be incapable of being criminally responsible by the presumption of doli incapax. And this is a presumption that can be rebutted by the prosecution. When you move to children who are aged 14 and over, they can be found guilty of a criminal offence without any such protections from doli incapax. Now, what's really key when we think about this 10 to 13-year-old group is how you go about rebutting doli incapax, because that is the fulcrum through which these 10 to 13-year-olds can enter into the criminal justice system. Prior to 2016, legal commentary from Professor Crofts indicates that there was a considerable amount of confusion about what was required to rebut doli incapax. And it kind of put the discourse in a position where doli incapax was being paradoxically criticized as being both too protective and not protective enough of 10 to 13-year-olds. At this time as well, the principles surrounding doli incapax were disaggregated across a lot of different legal decisions, which only added to the confusion. This changed in 2016 when the High Court released their RP and the Queen decision in December of that year. What RP did was clarify the principles of law that existed into a single decision, and I've abridged some of the principles on screen. I am not a lawyer, but I'll do my best to kind of walk through, in short, what these principles mean. The first is that the idea for the prosecution to rebut doli incapax is that they have to show that the child understood what they were doing was seriously wrong rather than being merely naughty. The second being this question of not being able to rebut doli incapax just by referring to how the conduct that occurred was quote-unquote obviously wrong. And this third being a burden beyond reasonable doubt. Now, RP as a decision had the effect of overturning convictions that were laid down against someone who was aged between 10 and 13 at the time of their offence, and it was brought by legal aid. Now, we believe that RP may have had the practical effect of making it harder to prosecute 10 to 13-year-olds. And one example of a potential element that could influence this, but by no means the only, is the second one, which in prior legal commentary from some judges in Victoria before the RP decision suggested that perhaps there were some offences that were so serious that you could just refer to them as having occurred as an explanation. And the High Court made a concerted effort to explicitly reject that point of view. But from a data perspective, why are we interested in a High Court decision? Well, the answer really lies on how the impacts of a High Court decision can reverberate through the criminal justice system and all the actors that sort of make decisions throughout the process, ranging from the police officers right through to the defense lawyers. But since we're dealing with a High Court decision, there is also another layer that could relate to national implications. While doli incapax is not the same across all Australian jurisdictions, there should at least be some signs of some national impact flowing from RP. So what this slide does is basically set up the structure through which I'll be talking about the results, lining up hypotheses relating to RP, and then talking through what the graphs actually show. I'm focusing today on 3 research questions out of the 5 research questions that are in the published Crime and Justice Bulletin if you want more information. I'm going to first touch on whether RP influenced trends, recent trends in New South Wales Children's Court, before looking at the rest of Australia and what RP can say about that. And lastly, I'll be touching on an alternate hypothesis and what we find looking at the time series trends there. The bulk of my presentation will be focused on comparing trends between what's occurred with 10 to 13-year-olds who are protected by doli incapax with the trends of those who are aged 14 to 17 and have no protections from doli incapax. We've got 2 sets of data. The first is New South Wales data from the reoffending database of finalised court appearances in the New South Wales Children's Court. And the second is aggregated statistics from a custom data extract that we've gotten from the ABS Criminal Courts data, and that spans children's courts across Australia from 2013 to the 2022 financial years. One final note on the proportions of the age groups within each of these data sets is that while 10 to 13-year-olds do comprise a minority of the cases that proceed through children's courts across the country, they still comprise a fairly substantial number at about 11,800 in New South Wales and 23,200 across the rest of Australia. Now, firstly, proceeding on to whether RP had any influence on trends in the New South Wales Children's Court. The hypothesis that we pose is that RP may have made it harder to prosecute 10 to 13-year-olds. And perhaps one of the impacts that may emerge from this is that police officers could potentially adjust their behavior over time and start to decrease their likelihood of having finalised court appearances against 10 to 13-year-olds. But when we look at the graphs, and so the rest of this presentation, I'll just note, we'll have time series graphs. On the x-axis, we have the finalization year. On the vertical, for this slide, we've got volume of finalized court appearances. And there's 2 vertical lines throughout each of these graphs, firstly representing the timing of the RP decision, and secondly, representing the timing of the first COVID stay-at-home measures that were applied in New South Wales. But returning to this particular hypothesis, I think it's worth noting that when you look at the trends for 10 to 13-year-olds, any decrease that's occurred in the volume of finalized court appearances appears to mostly precede the RP decision. And if you look particularly at the line for the 13-year-olds, that dark purple line, you can actually see that post-RP, there was a sort of slight increase before a dip, and then a return back to what is essentially pre-RP levels. When you look at 14 to 17-year-olds, there's also less of a sort of evident movement that's happened after RP. Instead, most of the shift, again, has occurred before the RP decision. So it doesn't appear that RP has had that much influence on the volume of finalized court appearances. But if we turn to another outcome, proven cases, magistrates have a bigger say in this decision. And if we're dealing with case law, we would anticipate that they would potentially be more swayed by a decision from a high court. So we should therefore expect to see a decrease in the proportion of proven cases. Looking now to this particular graph, which shows the percent of finalized court appearances that concluded with at least one charge proven, you can see the ages sort of next to each of these lines. I think there's a very clear distinction that you can see emerge when you compare 10 to 13-year-olds with 14 to 17-year-olds in terms of the percent of finalized court appearances with a proven outcome. I want to draw your attention especially to the 13-year-old line, which is the dark purple line, which is sort of separating the 10 to 13s to the 14 to 17s. If you follow the 13-year-old line, you can very clearly see that from 2010 to about 2016, there was a very clear and close sort of following of the trends for 14 to 17-year-olds as well. But as soon as it came to 2017, when the RP decision had kicked in, there was an almost immediate 10 percentage point decline that took place. A period of relative stability followed, before then a further acceleration of a decline that coincided temporally with the COVID pandemic. But interestingly, this decline has persisted well and truly into 2023, which is in the post-COVID period. Now, despite the sort of coinciding with COVID, we have reason to believe that perhaps what's happened in 2020 could be explained by reference to the BC decision from the New South Wales Court of Criminal Appeal. BC was an appeal decision, which was the first time, I believe, that RP was applied in a New South Wales criminal court appeal and saw the sort of convictions overturned of a 10 to 13-year-old. And we believe that it's possible that BC could have had a reinforcing effect in terms of reaffirming the position of RP in terms of strengthening the relatively strict threshold for doli incapax in New South Wales. Proven cases only consist a small number of the outcomes that we can look at. If RP has made it harder to prosecute 10 to 13-year-olds, we should also expect to see a corresponding increase in the acquittals that take place at defendant hearings. We should also see adjustments take place over time among prosecutors and defense lawyers. This is because prosecutors might clue on to the fact that it's getting harder to prosecute 10 to 13-year-olds and therefore may become more inclined to withdraw all charges against a defendant. Defense lawyers should also start to detect these changes and perhaps start to recommend their clients enter into fewer guilty pleas. Now, this slide shows a more detailed breakdown of the outcomes I was referring to earlier. And most strikingly, you can very clearly see for 10 to 13-year-olds that prior to the RP decision, proven by guilty plea was the primary means through which cases were being concluded in the New South Wales Children's Court. This was a situation where there was a very rapid decline to the point where by 2023, we've had just about 17% of cases finalized through this method. At the same time, we've also had a corresponding increase in the light orange line, which represents cases where all charges were withdrawn by the prosecution, which has moved in an almost converse kind of manner. That's gone from only about 6% in 2010 all the way up to more than 50% by 2023. So by 2023 in New South Wales, over half of the cases against 10 to 13-year-olds that were in the Children's Court were just concluding with all charges withdrawn against the child. We also see an increase in not proven at defendant hearing, which aligns with some of the other expectations we'd expect from the impacts of RP. And most stark is once you compare the 10 to 13-year-olds with the 14 to 17-year-olds, the 14 to 17s have had a much more stable series of trends in comparison to the 10 to 13-year-olds. And of course, 14 to 17s don't have any kind of protections from doli incapax. I've just shown you some pretty stark trends for New South Wales, and one of the first things I was thinking about when I saw them was the extent to which we can see any kind of changes nationally, or whether New South Wales is just experiencing some radical shifts. Given that doli incapax has some kind of form in all Australian jurisdictions, we should then expect to see some signs of a national impact from RP, given that the High Court has a national jurisdiction. I've got here that in the rest of Australia, we'd expect to see a decrease in proven cases, increase in withdrawn charges, but at a smaller amount than New South Wales. I'll explain why I say this is a smaller amount in a couple slides' time. But when you compare New South Wales to the rest of Australia, what's clear is that we do, in fact, see a diverging trend take place in the rest of Australia, in addition to New South Wales, even though what's happening in the rest of Australia is not at the same scale of magnitude. In particular, in the rest of Australia, we can see that they've gone from about 74% proven cases for 10 to 13-year-olds at about 2015 to 16, right down to 54% by 2022 to 23. So that's a 20 percentage point drop. It's a similar story with the withdrawn charges, where we've seen a very sharp increase in New South Wales, but also a notable increase in the rest of Australia, which has gone from about 12% withdrawn charges in 2016 to 17, and it's more than doubled by 2022 to 23. Now, one of the main reasons why I say that we expect the changes to be smaller for the rest of Australia is because the RP decision affected the interpretation of doli incapax at common law. And this is an interpretation of doli incapax that is followed by New South Wales, Victoria, and South Australia specifically, which draw upon case law for their understanding of doli incapax. compared to other Australian jurisdictions which have codified doli incapax in some form in their criminal codes and crime acts. So in Victoria and South Australia then, given that they follow the same kind of common law interpretation of doli incapax, we should expect to see similar magnitude decreases in proven cases and withdrawn charges as New South Wales. So what I've done now is I've broken down and looked at each of the Australian jurisdictions, and I want to draw your attention first to what's happened in Victoria. Victoria has seen an actual larger decrease than New South Wales in the percent of cases with a proven charge. They've gone from about, I think, 75% before RP all the way down to single digit by 2022 to 23. In South Australia, we've also seen a fairly significant drop in the middle panel there. You can see that South Australia has gone from about 50% proven cases before the RP decision and gone right down to single digits by 22 to 23. I've also left on screen the Northern Territory, and the reason for that is there's a fairly precipitous decline that's taken place there, but you can see that it's very clearly preceded the RP decision. What's more is that the Northern Territory follows an interpretation of doli incapax that is codified in their legislation and is different to the common law interpretation. There are two further states I want to draw your attention to. The first is Queensland. Now, most interestingly about Queensland is that the rates and the trends are seemingly identical, almost identical between 10 to 13-year-olds and 14 to 17-year-olds, which for me, the thought I had looking at that was what the role of doli incapax is in Queensland and how it's operating if it's producing such similar outcomes between these two different age groups. Western Australia is an interesting case in that there is actually a slight widening between trends for 10 to 13s and 14 to 17s, despite them following a codified version of doli incapax that is different to the same common law interpretation used by New South Wales, Victoria, and South Australia. They kind of occupy a sort of in-between point between New South Wales and Queensland, given that they've had an almost over 10 percentage point decrease since the pre-RP period. And it's a similar story when you look at withdrawn charges as well. For South Australia and Victoria, very dramatic increases, more so than New South Wales. They've gone from single-digit withdrawn charges all the way up to over 90% cases with withdrawn charges. And Queensland, almost identical trends for withdrawn charges. WA has a slight increase about by 10 percentage points. So an interesting divergence taking place there again. I'm now going to talk a little bit about an alternative hypothesis. So this is the case where we're dealing with the idea that we might have offences that are harder to prove starting to rise up for 10 to 13-year-olds such that they could overwhelm the caseload. So if we saw, say, child sex offences start to overwhelm the cases going through the children's court, then potentially that could explain why this is taking place in terms of such drastic changes in proven outcome trends. So what I've done is I've looked at the top 6 most serious offences with 10 to 13-year-old defendants. These comprise about 85% of the cases that go through the children's court. And you can see that there doesn't appear to be any stark increases in the volume of finalised court appearances for cases involving offences that you'd expect to be harder to prove in court. The main offences that have gone up are assault, which has gone up by about 29%, and robbery and others, which has gone up by about a single-digit percentage point. But when you look at proven outcomes only, there is a decrease across the board, irrespective of what offence type you're looking at. And once you go one step further and you start looking at the percent of finalised court appearances within each of these offences, you can see that for the majority of them, especially assault and property damage, the trends are very different between 10 to 13-year-olds, dropping at around the time of the RP decision, whereas the 14 to 17-year-olds have been relatively solid. So to conclude, we know a couple of things. We know that RP overruled a decision by the New South Wales Court of Criminal Appeals, which is a pathway through which it may have had a direct impact on New South Wales criminal justice system. And we believe that by clarifying doli incapax, RP has most likely made it harder to prosecute 10 to 13-year-olds. Given the national jurisdiction of the High Court, we've seen similar movements in South Australia and Victoria to New South Wales. And we've also seen shifts take place among defence as well as the prosecution, And interestingly, we're now at a point where more than 50% of 10 to 13-year-olds are having their charges withdrawn in court, despite not much change in the actual volume of finalised court appearances involving 10 to 13-year-olds. And we've also seen an acceleration in post-RP trends as well, possibly related to the BC decision. I will note that what I presented here is not a strictly causal analysis, but I think it's pretty clear that RP might be our best explanation for what's taking place. So I'll leave my presentation here and just note that doli incapax is currently under review in New South Wales for children aged under 14. And I invite everyone in the audience to have a think about what the purpose of the the doli incapax principle is, and whether it's sort of how we want to head as a state going forward in terms of thinking about ways that a codified version might look, whether we want to stick with the common law or whether we want to follow what another jurisdiction is doing. Thank you.
Okay, I think we have time for about 2 questions. One here.
Hi, James from the Aboriginal Legal Service. I was going to say thank you for the presentation, which was great, but the review has caused us some headaches, but here we are. And I think it does reflect, though, what we experience on the ground as practitioners. One thing I was interested in terms of looking at a statutory test in other jurisdictions, were there any stats for Queensland, which I guess is shown as the one that didn't have the decline that does have a statutory test, around the rate of conviction for matters that go to defended hearing as opposed to matters where there's a guilty plea prior to a defended hearing?
That's a really good question. I didn't look at that specific aspect because of the instability in the data and because of how the focus of this paper was on New South Wales. I know that Queensland has had some interesting recent developments as well with the BDO decision at the High Court level. I'm not a legal expert, so I can't profess to fully explain what's going on, but to the best of my knowledge, we have not seen, I don't think there is as much of a change in Queensland following that High Court decision in Queensland compared to what we see here in New South Wales. I'm also aware that Queensland might have a different bail regime, and so the legal strategies used by practitioners there could possibly put them in a position where proceeding to a defended hearing might result in remand risks as well. But I think this is an area that could really do with some additional research.
Hi everyone, my name's Aneka, I'm from the Director of Public Prosecutions. So your study focused on matters that were finalised in the Kids Court. Because we know all children's serious indictable offences move up to the District Court and the Supreme Court, did the study also include juveniles finalised in higher courts?
No, the study was specifically looking at cases finalised in the Children's Court.
But doesn't that seriously limit, if all serious crimes that are being prosecuted, and in particular the DPP is involved in children's serious indictable offences, where doli would play a huge part, doesn't that limit the findings that you can make based on limiting it to just matters in the Kids Court?
I think you raise a good point, and this is an area where doli incapax and stats around it have been very scarce across Australian jurisdictions in general. I think for us approaching the study, looking at the Children's Court was low-hanging fruit because the sample size was fairly considerable to the extent where we could actually get stats from other jurisdictions. Whereas if you start looking at higher courts and trying to do that for not for New South Wales, but for the rest of Australia as well, you start running into serious problems in being able to graphically represent what's going on. So our first port of call was at the New South Wales Children's Court level, but I would not be surprised if similar trends were happening in the District Court, and that's something that I think further research should definitely look into.
I'll just jump in, Melanie from Boxer. The number of serious children's indictable matters for a defendant aged 10 to 13 at the time of the offence that go to the High Court will be so small that I don't think any reliable conclusion will be able to be drawn.
Okay, thanks very much, Jonathan. Last but not least, we have Jake Prosecco.